Good morning, everyone. In History of the United States Constitution, I'm going to put up a little summary of some of the important concepts I believe that are embodied in the First Amendment expression portion of the First Amendment. We've just finished up with posting a little video on the clauses related to freedom of religion, free exercise clause, and the Establishment Clause, which is trying to avoid the government sponsoring or favoring or mistreating any religious entity or belief system unless they have an extremely compelling interest in doing so for some government purpose, which is a very narrow application. Now we're in what people think of probably as the most important right, especially when it comes to content, is freedom of expression. And most people think that that's the core of a democracy. In order to have democracy, there needs to be a free flow of ideas, no matter how repugnant they might be to some people. They need to be able to be expressed so that we can ferret them out as illegitimate or as vulgar. And if we aren't allowed to do them, and it's the government that suppresses them, we'll find that it's the poor, the unpopular, the disenfranchised that will have their voices squelched. And what's interesting about the history of it all is a lot of people think, well, we've adopted many of the British historical concepts out of their constitutional history and their sense of human rights or inalienable rights, and we wanted them embodied in our own nation. What is unique about the United States and about the creation of America's government is that we were the first to really embody that and put it in the Constitution. It wasn't in the Magna Carta. It wasn't in the English Bill of Rights. It was really born right here in the United States, this concept of freedom of speech. We thought it was so essential, and it was a unique claim, if you will, and it was born here. And that's one of the things I think we're most proud of. Sometimes if you hear things that you don't like and you think that are repugnant or offensive, you might think differently. But overall, I think most of us in a unemotional setting will often acknowledge that freedom of expression is the most fundamental important right, and it's probably the one the government has the most difficulty in ever trying to regulate, because we don't like it. We acknowledge it's a very slippery slope when they do, and so we've set up very difficult tests and standards for when and under what circumstances they might be able to do it, especially when it comes to content. In fact, the government almost can't curtail content or views unless they meet certain very specific standards, and we'll go over that in this video right here. And the other thing you have to remember is when you read the First Amendment, it says Congress shall pass no law. So for a long time, this was only a limitation on the federal government interfering with your ability to express your views. That expanded to states later on, but for a long time, it was only the federal government that we were worried about. So southern states were using this principle to avoid information being disseminated that was about abolitionists before the Civil War that ended slavery with the 13th Amendment. The state governments down south would actually intersect propaganda or mail that was anti-slavery. They would squelch the voices of people that were in dissension over slavery and other issues related to governance. It was done all through the states, but the southern example is much easier because the First Amendment didn't apply to state action. That changed through a process called incorporation. It's true of all of the fundamental rights in the Bill of Rights. They were not universally applicable to the states, and they didn't, just because of one case, suddenly become applicable to state action. It was piecemeal through a process of incorporation. It's true of the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment. They all became applicable to state over time. In fact, the Second Amendment, that case only came out in the 1990s, making it perfectly clear the Second Amendment, the right to keep and bear arms, under some parameters, are applicable to the states via a case from the Supreme Court. So some people think, well, and one is Hugo Black. He's long since dead, but he's one of those guys that's both my hero and I'm concerned about him a little bit too, because he does come from a racist background. But he was a big believer Congress should pass no law whatsoever curtailing speech of any kind. You're free to say anything you want. He had an absolutist view of the prohibition of government interfering with free speech, and some of you could support that. But then when we get to the areas where the government is allowed to squelch speech in certain fashions or in certain ways, you might say, yeah, there has to be some ability of government to limit speech in certain capacities. What am I talking about there? Obscenity. I'm not talking about just vulgar speech. In fact, there's a test for obscenity. It's a very difficult one to pass, and it's very narrow. But the others, things like sexual harassment. We don't want people to be allowed to be in a workplace and sexually harass other people at work because it interferes with the victim's rights. Also, defamation, libel and slander. One's written, one's oral. We don't want people to go around telling lies about other people that impact their lives psychologically or economically in their community. We also don't want people to be able to go out and give out military or national security secrets, even though they may possess them. They shouldn't be able to publish them or communicate them to other people. That speech should be limited because it endangers human life and property of other people. And so there are obviously limitations on speech in certain fashions. But it is very narrow. And the history of free speech is very fascinating. And this is a history class, technically, in terms of its labeling the history of the Constitution. Where it really was shocking was after we adopted the First Amendment in 1791, but right around 9 years later, we have the election of 1800, and John Adams and the Federalists actually passed a law called the Alien and Sedition Act. Don't worry so much about the alien aspect. Basically, it was an anti-French movement because the French Revolution had occurred, and there was really two camps, one that had more ideology affiliated or associated with the British conception of governance and civil propriety, and the other was inclined to adopt the more radical view of the French Revolution. And so there was an anti-French movement, and there was concern that we might have a second revolution here in this country. So that was the alien part, to basically remove people that were not United States citizens from this country that might pose a risk. That's not what I'm talking about in this class. What I'm talking about is the second tier of that statute called sedition. And basically it outlined criticism of the government. Imagine that today, that if we said we're going to pass a law that if you criticize what President X is doing or Congressperson such and such said, and that we shouldn't be able to speak out for or against these kinds of views, or we risk being fined or jailed. That's what happened in 1800. And Thomas Jefferson and James Madison were so upset, they wrote something called the Kentucky, and this is going to be in a test, the Kentucky and Virginia Resolves, because this is a history class. You have to know the roots of the First Amendment. They were so upset with the Sedition Act, saying it was so fundamentally unconstitutional and inconsistent with these inalienable rights that we believe about self-expression, especially when it relates to government, that states should be able to have the ability to basically veto laws that they deem contrary to the Constitution. That was the first sort of constitutional crisis we actually had in this country, was over this Sedition Act. And there was a congressperson that was actually jailed for criticizing John Adams. And there was a publisher jailed for a period of time for printing things in their press that was critical of the Federalist governance at the time. That's shocking to me. Imagine that. Imagine saying something critical about your state or your federal government, and you don't do it with violence, and you don't do it with a call to arms, but you basically say these people are doing awful jobs or they're incompetent or something like that. Imagine being arrested and thrown in jail for that. I think most of us would find that repugnant. But right at 1800, it was a very, very much a black eye to John Adams. A lot of people think of John Adams very heroically here in Massachusetts. He's from Massachusetts, practiced law for a period of time in Worcester. It was obviously a clear patriot in terms of giving birth to this nation, but nonetheless, he was a proponent of the sedition law, and he had it enforced, and he basically used it to target his enemies. And it's really sad. Like most people in history, not everyone's perfect, and that's probably one of his biggest flaws, was the promotion of the Sedition Act. There was a clause within that law, however, it's called the sunset provision, that it would die on its own accord anyway, so they never had to repeal it. It never got to the Supreme Court to be overruled. Remember, we didn't have the Marbury versus Madison case where federal law could be struck down by an interpretation of the Supreme Court until 1803. But boy, there was a period of time that we were really fighting the good fight over what government could do in terms of limiting speech. And right now, if you want to think of one form of speech or expression that's most sacrosanct, most likely to be protected from government interference, it's political speak. We allow people to speak no matter how wacky, crazy, vile there, unless it doesn't do what? And that's when we get to the test about when you can limit speech, as long as it doesn't incite immediate violence or the avocation of the overthrow of the government in the moment. Believe it or not, it's actually protected speech to say, I think it's a good idea that we get together and find a way to become armed and become powerful and we should overthrow the government and create a new form of government. That would probably be protected speech because it lacks immediacy in the request. It'd be different if I said, we're going to meet down this park, bring all your guns and knives and bombs and all your equipment, and we're all going to gather up and we're going to set a caravan, or we're going to go up to Beacon Hill, or we're going to go down to DC and we're going to throw it over. That kind of speech would be to incite violence in the moment or very imminently thereafter. That could be punished and curtailed, and rightly so. I mean, the Constitution is not a suicide compact, and so we have to have reasonable restraints on speech. But it is very, very difficult for the government to meet that burden when it is reasonable. Yeah, so they wrote the Virginia and Kentucky resolutions, asserted that states had the power to declare laws like the Sedition Act unconstitutional. That comes up later. That was the Civil War, in 1860. But that ferment, that belief that if something in the federal system was so repugnant to a state, because we were a union and you joined it voluntarily, you had the same power to remove yourself from the mandates of the federal government. So these views were underlying in history for a long period of time, all the way back to 1800. And so after that, the Sedition Act, like I said, expired in 1801, and not until 1917 was another new and done. 1917, ring a bell? Well, not to you guys, not to me either, unless you're into history. What's World War I? And what do some people think about World War I? In fact, just on the eve of it, Woodrow Wilson ran on a campaign. He kept us out of war. Right after he gets reelected, we go to war. We go to World War I, and not everyone was in favor of it. We had a very isolationist view that much of the nation did prior to that. Stay out of these European entanglements. We have no business there. In fact, we were constantly passing resolutions, if you will, of neutrality. We wanted to trade with everybody, although we traded much more with the Allies than we did with the Axis powers. But nonetheless, it was a real undercurrent of stay the hell out of there. But when we started to realize that because of the unrestricted submarine warfare and our economic interests were at stake, and there was this thing called the Zimmermann Telegraph that was sent out from Germany to Mexico, saying they'll help Mexico regain the states of Texas, New Mexico, and Arizona if they side with the German the Allies. And so that triggered war. We know there was other events as well too, the sinking of Lusitania and other events like that led us into war. But there were many people right in the moment of enlistment and conscription of soldiers and sailors saying, don't do it, don't go. And some of those people actually were jailed. There was this is shocking, just basically saying, not calling to arms, any kind of violence at all, but basically saying, don't go to the draft, burn your draft card, don't fight for a war that's about money or for Europeans or whatever. Listen to this. The federal government convicted more than 2,000 people of violating the Espionage Act. One of my favorites, because I'm a history junkie, I'm a nerd, that's what I got going for me. I even put stuff on my walls that are related to history. One of them is a guy by the name of Eugene Debs. He was a big labor leader, and he ultimately digressed and unfortunately went away from being just a mere progressive. He turned into a socialist and later a communist, but he spoke out against World War I, saying it was really on the back of the working people and things like that. And he had these rallies and he told people to disobey the draft. And the government said, no, we have an interest in maintaining the draft and maintaining. You can't undermine the war effort. If you undermine the war effort, you are hurting the government's interests. Therefore, we have a right to curtail it under the new 1917 Sedition Act. And Eugene Debs did several years in jail. He got a very long sentence, but a later president, I think it might have been Hoover, pardoned him later on. And he ran for president from his prison cell. And I don't have the button, but it's one I'm always looking for. I don't want to buy it on eBay, although it's available for several $100s. I always want to find it at some freak estate sale or something like that. It's Eugene Debs, vote for Eugene Debs, and it has a convict number. That's how because he was proud almost of being convicted by a government that he saw as a bit totalitarian. I wonder if that would happen today if the nation were actually in a true world war where conscription of service members was very, very important, and people got up and said, don't do it, don't go, protest it, burn your draft card, refuse to go. If those people that said those things, and we had a new Sedition Act, we don't have one right now, but if we did, would people be jailed? I think it would be unlikely. I think we've really come as a nation, conservatives or liberals, don't want speech curtailed unless it's an actual call to violence or it's something that actually does undermine the the safety of human life and property. Sometimes even in property, the government might have a right to get involved. Yeah, the first case, and I might put a test question on about Schenck. It's Schenck versus United States. The Supreme Court held that the Espionage Act did not violate the First Amendment. With that case, the court began the long process of trying to determine what is free speech and what are its limitations. Schenck today, although it's never gotten overturned directly, arguably by later cases, it suggested that Schenck would survive today's Supreme Court interpretation of what kind of speech could be curtailed. I think that kind of speech would actually be allowed as long as it wasn't in the immediacy of undermining the human health and safety of United States citizens. But Schenck is the big one. And every so often, I don't have cable anymore, but when I did have cable, I'd be flipping through the nerd channels when I couldn't find something to do. And they had these things called CNN and other, I don't know what you would call them, like round tables of people that are just want to talk about nerdy topics. And every so often I'd be flipping through the channels and I'd see in the bottom goes a revisit of Schenck, and I'm like, oh, I got to watch this, because it would be philosophers and politicians and historians and lawyers talking about the history of people being imprisoned for speaking out against government action in the theater of war, and whether or not that would likely be upheld today. I think the consensus is probably not, unless it was overt action to stop people from entering into other than just the spoken word, the idea. Ideas are protected almost universally. Very difficult to get into the concept of idea restriction. Otherwise, we're in that the book 1984. So there's different kinds of speech. Pure speech, just spoken words or written words, those have the highest degree of protection. And if you want to get into, certainly, are some words more important than others, political speech is the highest form of protection that we want to maintain. That's pure speech. Speech plus is not only that you're speaking out about certain things, but you might also be marching or demonstrating or doing demonstrative activities. There, the government might have a greater ability to potentially curb that because of human health and safety, or just the needs of government or society moving forward in a certain way. So that gets the highest degree of. And then there's symbolic speech. I'm not actually saying anything, but I might be burning it, not me, but somebody might be burning an American flag, or they might be wearing a ribbon or a symbol or something that shows their affinity or disgust or disdain for a certain event. That's protected speech as well, but it might not receive the same protections as other forms of speech. In Texas v. Johnson, that's the big one, burning American flag. And a lot of people think, well, we got to pass a law. And they do. And the federal government does from time to time. Try to pass a law to ban the burning of the American flag, because it's sacrosanct, right? We honor the flag. We were always raised, most of us at least, were raised to salute the flag and do those kinds of things. In my old home where I grew up with my parents, I used to have a flag with 48 stars on it, filled up my whole wall. It was huge. And I honor the flag. But the thing is the question is, does somebody who's burning the flag to symbolically show their outrage over something the United States government is doing, is that protected speech? And the Supreme Court said yes. So if it's protected in the Constitution, the only way to override that isn't by a statute. A statute can't override the Constitution. The Constitution is the highest law in the land. So people get really frustrated whenever so often the federal government would pass some statute saying you have to protect a flag in a certain way, or be illegal to deface or destroy the flag. That can't defeat the constitutional ruling. So what could, if the nation really wanted to, protect the American flag? It would be amendment to the United States Constitution. That's the only way to change constitutional interpretation, or get the Supreme Court to change your mind. They won't. Even very conservative justices about protecting the flag recognize that vulgar, disdainful, unpopular speech needs to be protected, and that is a form of speech, symbolic speech. All 50 states have had polling done in the past that they would agree to this constitutional amendment. You only need 38, but you also need what? 2/3 of the House and 2/3 of the Senate. And you got to remember who's in the House and the Senate. Many of them are lawyers and legal scholars, and many of them are fearful that it's a slippery slope, that if you start trying to put in the Constitution things about symbolic imagery, how far does it go? And speech, no matter how repugnant, really needs to be protected. Let me see where we're going to. So what are the limits? In here, they start off with obscenity, the most difficult concept of all. Obscenity doesn't mean offensive. Offensive speech is protected. I think hate speech is protected. I'll get to that in a second. So obscenity is really about certain kinds of pornographic It can be speech, it can be imagery, it can be photographs, it can be motion pictures or videos, but it has had a difficult time for the court to define it. So, can the government regulate obscene speech, sexual depictions? Yes, but it has to meet a very high standard for it to do it. I can tell you right now, as a general rule, the only one I know that's clearly going to violate a concept of obscenity and withstand court challenge is child pornography, because the government has a compelling interest in protecting children. And there's a lot of scientific data knowing that children engaged in underage sexual activity that's videotaped and disseminated causes harm to children. There's no question about it. So the government has a very compelling interest. But other than that, when it comes to consenting adults, the courts had a very difficult time. And one justice, I'm glad they put it in here because I was going to look it up. One of the famous ones, they were debating, well, what does it mean? How are we going to define this so when governments try to curtail certain kinds of depiction of sexual activity, we can shut it down? And the only one they can have a real consensus on is child pornography. So the other kinds of adult depiction of sexual behavior, when can they do it? Well, it's one of the few standards that's actually regional. Usually you think we have uniform laws throughout the United States. That's not true, because they created this test. It's called the Miller test. I will put the test on the exam. It's kind of a double entendre there. The court came up with Miller, a certain test, but before that, when they were debating, the justices were talking about the different kinds of, what is obscene under sort of pornography. Basically, pornography can be banned if it equals pornography, and to equal pornography, it must be obscene. So what people usually talk about pornography, it's probably protected. We're talking about stuff that violates that. And one of the justices, Justice Potter Stewart, with interesting care, he goes, when it comes to hardcore pornography, the only time I can really know it is hardcore pornography, I'll know it when I see it. It's that difficult a thing for people to wrap their mind around about defining it. And we don't put it up to popular opinion. We put it up to what the Constitution mandates, and the court tells us what the Constitution mandates. And it comes out of the Miller case. And here's the test. 3 elements, 3 prongs of the test, if you will. The first, whether the average person, not the uptight person, not the very liberally minded person when it comes to this kind of stuff, the everyday person, the amalgamation of all of us, the middle of the road kind of person, applying contemporary community standards. Are community standards different in, a rural southern town versus Las Vegas or New York City? Yeah, they are different. And so regionally, you could have different definitions of obscenity, really. So, based upon the contemporary community standards, would find that the work taken as a whole appeals to the prurient interest alone, the sexual interest alone. 2, whether the work depicts or describes in a patently offensive way sexually conduct specifically defined by the applicable state law. And I think what the court has a real problem is, what the hell does that mean? What is patently offensive to the average person? That's where Justice Potter came in and said, you know it when you see it. And third, and this is the one where you can see some history in the regulation of the adult film industry, they would try to put in things like music and educational statements about things to get around this third element. The third element is whether the work taken as a whole lacks serious artistic, political, or scientific value. So they would often try to incorporate those elements in order to get around this rule. Courts had an extremely difficult time regulating what we consider to be adult depiction of sexual behaviors to be disseminated only to adults or to be used by adults. Child pornography is the only one that comes very, very clear. So what is indecent? What is obscene? I don't know when you apply those tests. I mean, I guess I could make that argument if I was representing either the prosecution or the defense side on a question. We would try to apply that test the best we could, and it's really up to the jury to determine. But if we appealed it, we'd appeal it on a question of law, and the appeals court would have to have a clear ability to apply it. Otherwise, the law is considered what? Void for vagueness. The law has to have clarity so people know how to abide by it. So child pornography definitely is out. The government has a very strong, compelling interest because they can prove why they need to do it. Otherwise, it's pretty much all. And they have a picture of John Ashcroft in here. I actually use his book for business law. John Ashcroft, he's pictured in your book with a picture of, I think it's Lady Liberty behind him, or the Spirit of Justice. It's a statue of a woman, and she's partially topless. One of her breasts is exposed. Believe it or not, for a period of time, he actually had a screen put up because he thought it was obscene. He's a very conservative individual. It's not his opinion of what's obscene. It's really what the makeup of the court is, and it's based upon the average sort of personal view of all those three tests. Very difficult. Defamation. The government does have a compelling interest to disallow or to punish those people that engage in defamation. There's two forms of defamation, libel and slander. Libel is written words, slander is spoken. And it has to be what? It has to be a falsehood of fact, not of opinion. I think that person's a jerk. That is not subject to defamation, because what is a jerk? It's not a measurable, quantifiable quality. But what if I said that person was convicted of larceny in the past, and it's a falsehood? I publish it to a third. And publishing doesn't mean it has to be in a newspaper. Publishing means just I tell another person this about Jane. Jane is a convicted larcenist. She's a thief. And it turns out it's not true. She can sue me for defamation. She has to prove she has damages, economic or emotional, and she can sue me for defamation. The problem with that is what if Jane is a thief? What if she does have a conviction? Well, then I'm speaking the truth, and that's the old saying. Truth is an absolute defense to libel and slander. The other thing you should know is the courts have decided that we don't want people to put a chilling effect on people talking about people in the public realm. So people that have a public persona, especially politicians, but actors, people that are in the forefront of social movements, people who are basically famous, we want society to be able to freely talk about them and not worry about making an error of some fact about them. And so we have created even a higher standard. It's called, in order for a public figure, and that's even debatable, what's a public figure now? I was a selectman in my town in Sturbridge, and somebody once said something about me that was not true, although it was comical in the end what it was about. It wasn't true, and I was upset about it because friends of mine were calling me up saying they misprint. They put a correction in the newspaper a week later, and of course they put that in fine print in a different section of the Frankfurt on the front page. But am I a public figure? Well, not in the world of a public figure, but not local community where the published paper. I probably was a public figure. And therefore, I'd have to prove what if I wanted to sue the newspaper? Something called actual malice. It's just a term meaning I'd have to prove that they didn't print it negligently or accidentally or carelessly. I'd have to prove that they knew it was a lie and they printed it nonetheless. It has to be intentional, because we want what? We want public officials and we want people in the public arena to be able to have discussions openly. And people get really outraged by it. Politicians get very upset because, let's face it, people do lie or they spread rumors that are not true. And a lot of people think we should be able to sue for that. But what would it do to the discourse about politicians and political leaders? It would put a huge chilling effect if anybody that ever talks about them would be fearful of a legitimate lawsuit succeeding. So that's libel and slander. The next one that the government has a compelling interest. So we got obscenity. Government can shut down obscenity. The only one they've been really successful in making clear definition of child pornography. But if they can define it better or clearer, they might have some success. Defamation, went over that one. Next one's fighting words. These words can be curtailed by the government because fighting words will lead to violence. And I don't always know what they are, but if they're so likely to trigger a reaction in the people listening it to cause violence, not outrage, but violence, the government has a right to curtail that speech. It's rare. Then give me some examples here. It says, the Supreme Court upheld the conviction of a guy named Chaplinsky, a Jehovah's Witness, for calling a police officer a damn fascist and a racketeer, because that might likely lead to violence from that officer. The N-word is a classic one that people argue is likely a fighting word. But you got to be careful about this next one. That segues right into hate speech. Can the government limit hate speech? Can they say you can't speak negatively about a person's religion, their race, their ethnicity, their economic standing, how long their hair is, how fat or thin or tall or handsome or ugly they are? I think the book could have done a little bit of a better job here, because generally speaking, hate speech is probably protected, meaning we're free to hate people and we're free to say we hate people and we're free to say terrible derogatory things. I don't think it's right, but I don't think the government should be in the business of regulating personal views about other people. I'm a big believer in inclusion, and I'm a big believer in being kind and respectful for people that are very different from me. But I don't think it should be the government's job determining when and under what circumstances somebody crosses the line and creates hate speech. Every hate speech code that's ever been tried to be implemented and has been challenged, the challenger always wins, with one major exception. So if the government tries to say, City of Cambridge tried to do it not that many years ago, they wanted, people on the street, I guess, were swearing a lot. They wanted to curb people from vulgarity. Luckily, it never ultimately got past the Attorney General at the time. So it can't pass this. It violates the First Amendment freedom of expression. But what redeemable quality these terms have doesn't matter. The government doesn't have the business of curtailing even hate speech. There are things called hate crimes that are constitutionally valid by the government. This is when, if somebody goes and commits, in and of itself, going and hating someone who's a homosexual, or hating someone because they're a woman or a man, or because they're gay, or because they're of a certain racial background, or a certain ethnicity, or a certain religion, that's protected. You can hate them, and you can even voice your hatred against those people. And I'm always surprised when I hear somebody said something, really inappropriate, and the police are looking into it. Well, go ahead. You can't do it. And some of these people get charged. Those charges won't go very far. However, what if they coupled it with an underlying crime that's neutral in terms of expression? So if if my client goes out and beats somebody up because they're a homosexual, beats somebody up because they're a woman, or because they're a Muslim, or they're a Jew, or whatever criteria that is articulated in the statute, now the punishment can be deemed more advanced because of the motivation was derived by hate. And it's usually an immutable characteristic like race, color, creed, national origin, sexual orientation, sex, those kinds of things. So in and of itself, hating someone because of those immutable characteristics, that the government usually can't regulate. But when you do a crime like assault and battery, malicious destruction of property, larceny, and you're motivated, I don't know how the government has a hard time proving this, motivated by that kind of discriminatory belief system, the punishment can be enhanced. A lot of people, it's very controversial. I had a case not that long ago. Two guys were in a road rage situation. I don't think either one of them knew what their race or ethnicity was while the road rage thing was going on. They eventually pull over into this parking lot, and they recognize each other as being identified as certain ethnicities or races. And so while they're beating the crap out of each other, they're saying, you dumb this, you stupid that. And they both got charged with hate crimes. Well, the case was probably going to be dismissed because both parties would probably take the Fifth Amendment, because either of them, when they testified against the other, they'd likely incriminate themselves. But in talking to the DA, the district attorney, I was saying, these guys really don't hate each other. I'll give you the example. Actually, one person was Greek and the other was Puerto Rican or Hispanic. And they were saying vulgar terms back and forth based upon those racial and ethnic identities. And I said, the only reason they were saying those things while they were beating up each other wasn't because they hated people that were Greek, or they hated people that were Puerto Rican. They were doing is they were mad over a road rage incident. They were just simply trying to insult each other. And the district attorney agreed with me. So before the case was ultimately dismissed, the charge of the hate crime was dismissed from both of them. So it has to be established in a hate crime is that the crime, the assault and battery, destruction of property, the thievery, the arson, whatever the crime is, you have to have the baseline crime, and then they have to prove beyond a reasonable doubt it was motivated by hatred of one of those underlying immutable characteristics that the statute would embody. It's a very controversial topic. I have mixed feelings about it because I think people sometimes are mad at somebody, but then they want to be offensive and hurtful, and so they add in language like that, and it has really nothing to do with the true motivation of the defendant. Very difficult. Speech that incites legal action, and that's the one that's the most interesting. We had Oliver Wendell Holmes made the most famous one. You can't yell fire in a crowded theater because people are going to rush out and get hurt. So you can't do speech. And the first test under the very first case was Schenck again. And Schenck created a test called clear and present danger. And a lot of people think that's what we still have. If the speech creates a clear and present danger of property damage or human physical harm, the government has a right to curtail it. That's been even brought back even further because Schenck was basically telling people not to listen to the military. And and the view became much more settled that goes too far. It's giving government too much power to control expression. And so now the test is under Brandenburg versus Ohio, and I'll post that. It's imminent and probable that violence and human health and safety will be put in jeopardy. Very difficult for speech to rise to that level. In speech in school, because there's a function that the school is supposed to perform to educate children and to keep decorum and things like that, speech isn't as free in a public school. So it has to be public. If I'm in a private school and I'm saying, I'm not so crazy about Jesus, can the school expel me? Yes. I don't have freedom of speech in my private workplace. If I'm working at Walmart and I'm speaking out against, I don't know, I think Target's a better store. He goes, well, we think you're disloyal or firing it. I can't say I got free speech. It's going to be the government curtailing my speech. But if you're in a public school, like the Mount or a public high school, Monty Tech, I don't know all the high schools up in the northern Worcester County area, Athol High, I think it's called Athol Royalston Regional School. That's a public entity. So in order for them to curtail speech, they have to have a compelling reason. But don't they have a compelling reason in the midst of educating students to keep a certain level of decorum? And the answer is yes. So it's a little easier for the government to curtail speech by students, but symbolic speech, you want where an armband or a symbol or something like that is probably more likely to be allowed. But speaking out in class or speaking out in the hallways or saying things that disrupt the orderliness of the school could be curtailed. In fact, back when I used to do juvenile law, I'd get students charged all the time with just disturbing a school assembly, because the assembly, even though they weren't an assembly, they always try to argue that element. But we can see that as a common sense principle, that there is more government interest in curtailing speech, not because of content. Content almost can never be curtailed. What can be? Time, place, and manner. So they have more control in that school system. Think about it. If I want to do a big speech today, I can't do it right on the 4 major intersections in Kelly Square and Worcester out in the road, because I'm going to impact traffic. They can't curtail my content of my speech, but they can do it in time, place, and manner. You got to be on the sidewalks. You got to be at a reasonable hour. And you can't be screaming in megaphones at 3 a.m. because you're going to be waking up people in the apartments that surround that area. So time, place, and management restrictions by the government have often been upheld, as long as it's not designed to put a chilling effect on content. And now we get to the next one, the press. These go hand in hand in many respects, but the press keeps us free. And right now the press isn't very popular. It ebbs and flows because the press isn't quite what it once was just elucidating facts. It's much more now about people in the news media. I think this is a commentary on my part. They don't tell us what happened. They tell us what to think about what happened. And I think that's a detrimental. It's much more about commentary and wanting us to draw certain conclusions. And that's dangerous, but it's certainly protected under freedom of speech. But why is the press specifically put in there? Because we know during the Revolutionary era, things that were printed were often punished as being repugnant to the king. And we wanted people to be able to, and it's in the First Amendment, there's 5, freedom of religion, freedom against state-sponsored religion, freedom of expression, the right to assemble, the right to petition the government without fear of redress. And now I'm not going to spend too much time on assembly or petitioning the government, because they go hand in hand with the concept of freedom of expression. But the press was seen as a very important institution to create transparency in government. And we wanted the press to be able to go around and print things, especially related to politics and cultural phenomenon, in order for us to have transparency on what was going on without fear of being shut down by the government. Very, very significant rule. So, and we know for a long time, printers went to jail early in our country's history under seditious libel. And we know guys like Thomas Jefferson and James Madison were outraged by it. And the first case that came up, this is even before our Constitution, there was a guy by the name of John Peter Zinger. He could hardly speak English. People were writing articles, and he just had the printing press basically, and he'd print these articles that were derogatory towards the government officials. And Zinger got tried for seditious libel. And all he had to prove was, did he print them? It didn't have to be, you couldn't use truth as a defense, but this attorney he had put up the evidence that it was truthful, and the jury refused to convict them. And that changed the attitude of the colonists. The American citizens really changed their attitude about seditious libel, that truth is an absolute defense, meaning you can't be charged with libel if you speak the truth. And the movement really started to be giving that you really shouldn't be able to curtail the press or things that are put in the press when it relates to government criticisms or just information about the government. Now, there's a concept I want you to know about. So freedom of the press, critical to a real democracy. People should be able to report about what they know. But sometimes there's information that people try to put in the press that the government says is harmful to the interests of America. And so sometimes they try to say, we're going to stop you from printing that. We're going to stop you from putting it on a blog. We're going to stop you from putting it on an evening news or on a video. And that's called prior restraint. Sometimes people gather information and they get it illegally. They somehow bypass national security or protected information systems. They committed a crime, and that crime can be punished. But could the person still publish it? And that came back in 1973 in a very famous case called the Pentagon Papers. I don't know, the New York Times and I think also the Washington Post. This guy named Daniel Ellsberg, yeah, he's in the book mentioned here. He said, I thought I'd probably go to prison for the rest of my life. He was working for the Pentagon at the time, and he saw that it's not that much different than this guy, Jon Snow. Got all this information. Look what the government in this report saying, how bad the Vietnam War is actually going, even though they're reporting out, that we're kicking ass over there. Things were going very, very poorly. So he disseminates these Pentagon papers, basically proving the Pentagon knew that the war in Vietnam wasn't going very well. He gets charged. But what did they do before he gets charged? They try to prevent the New York Times and the Washington Post from printing the Pentagon Papers. And the court says, why? Why are you trying to restrict the press? And they tried to argue that if the Pentagon Papers were released, it would hurt the war effort in Vietnam. And they said, how? And the government couldn't prevail. It's a very heavy burden for the government to stop the press from printing an article. Does that mean Daniel Ellsberg couldn't be punished if he revealed secrets that the government wanted to keep? Yeah, he could be punished, and he was punished. It became unpopular, so I think he got a pardon later on. But generally speaking, what if I somehow hacked into the, information about something? The government couldn't ban me from releasing that information unless it was going to reveal something about national security, troop movements or how to undermine, the nuclear armament codes or something like that. Then the government obviously has a compelling interest, and it's met its burden, a very heavy burden, to do prior restraint. But very rarely can they do it. And it came out in Abu Ghraib, that was a prison I think we had in Iraq, where for some reason some of the guards and the military people that were responsible for that prison were taking photographs of probably enemy combatants, but they were often posed in very graphic, naked positions and humiliating acts and things of that nature. And it was going to be printed in Newsweek or Time or whoever. And the government tried to do prior restraint. Goes, you can't print that. It's going to undermine our effort to create peace in Iraq. And the court says, well, how will it undermine it? And my favorite statement was that the enemy will be outraged and want to fight even harder against us. They really couldn't come up with an argument other than embarrassment. And so therefore, government information can be usually, unless it does what? Unless it truly does undermine national security. And again, about libel, I already talked about that. Got to prove actual malice, very difficult to do. So the burden against prior restraint is so great that the Supreme Court has not overcome, even if the defendant right to a fair trial can be disseminated. And what do they do? The court has to protect the court process. So that's why they often sequester jurors not to be able to read the papers or listen to the news or look at videos or anything in between, and to put them up in a hotel. Nowadays, sequestration is very difficult because people can access all kinds of information right on your cell phone about the nature of events, but you're ordered not to. And if anybody finds out you've done, you violated the sequestration order. But did it stop the press from printing articles about the ongoing trial in the stories around those trials? No, the press is free to do that. Prior restraint is so taboo that you really got to prove that human health and safety and lives will be lost if the press goes out and prints these things. I already talked about actual malice and the right to people to peaceably assemble. I'm glad it's in there. It doesn't come up too much in case law, but think about it. When people were meeting, government would try to break up those meetings because they would be often rallying grounds for dissent. And we know down south for a period of time until the First Amendment was incorporated to be applicable to the southern states or any other states, the South was often preventing civil rights and African Americans from organizing, unions from organizing, all these different groups from organizing. But because it's protected in the First Amendment, the right to assembly is pretty much protected now. Sometimes the government might have an interest in, you have to hire a police officer or get a permit because of traffic flow or things like that. But it can't be designed to put a chilling effect on people's ability to affiliate with one another. And that's the same with petition, freedom of association. And it really surprises a lot of people. People think the court actually did. The Massachusetts court did. I'm thinking about the Irish, some call it the Irish Festival. But the St. Patrick's Day parade in Boston is not a state or municipal run parade. They participate in a lot, but it's a private organization. I think it's the Ancient Order of the Hibernians or some club up there. They run the annual St. Patrick's Day parade. And guess who they wouldn't allow in there for the longest period of time? Well, they wouldn't allow certain groups that were affiliated with gay and lesbian organizations wanted to put a float in the parade. And they said, no, you can't march. You can't have any involvement. We don't want you there. We don't like you, whatever. These people sued, and it went all the way through the state court system, and they sued basically a violation of the civil rights to participate in this parade. And the Massachusetts court said, yep, you got to let them in. You got to let them in. And the guy that the organization brought it all the way to the United States Supreme Court in a shocking reversal. A United States Supreme Court unanimous decision says, the right of assembly is also the right to affiliate, and we're free to affiliate with whom we want. And privately, we're also free to do what? Privately, we are free to not affiliate with people that we don't want to. So the Supreme Court of the United States disallowed the application because the private organization said they can allow whoever they want and they can discriminate against whoever they want because it's a private entity. Now, people say, well, there's gays and lesbians marching in the St. Patrick's Day parade today. What happened? Politics happened. And that's one thing about political pressure. People started having a change of view about these concepts. And basically people said, you know what? Our organization's not going to participate in the St. Patrick's Day parade unless you let the gay and lesbian organizations in. Or, I think it was Mayor, who's now in the federal administration, Mayor Marty Walsh said, the mayor's office isn't going to march, and he urged other organizations not to march too unless these gay and lesbian organizations were allowed in. So it was through voluntary agreement to affiliate and allow these people to participate. It wasn't through court action. The court said you have a free right to discriminate against certain people. Heckler's veto, I'm not going to do. And you got to remember, peaceably assemble is in public spheres. You don't necessarily have a right to go in a private organization and say, I want to have a meeting in here. It's not your property. You can't do it. And some people try to do that in malls because malls are often thought of as a civic sort of arena for people to get together because there are demonstrations, but you have to get permission from the mall. They have a right to refuse you because it's a non-public place. Yeah, freedom of associations on it. I was kind of all over the place. The book does a wonderful job. I'm going to put up some videos on it. I go way too long in these videos, but there could almost be really a whole semester class just on the First Amendment, just on the subpart of freedom of expression and when can we limit that. And I've had a fair amount of cases in my day where people were arrested and charged because they said some really terrible, vulgar things, but they're protected, and the speech is protected. And when you're the one speaking it, it becomes a little bit more salient to you and more understandable. And when you hear other people saying really rude and inappropriate things, boy, it's hard to fathom why it is. But we want, just think of it, if it's you and you have certain views, would you like the government to be able to squash or put a chilling effect on your ability to communicate them as loud and as proud as you want to, as long as you're not going to endanger human health and safety on the other side? And that's really the bottom line test. Otherwise, be well, folks.